The Second Amendment is made up of 27 words arranged into just an extremely odd sentence. It says, a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. So how should we read this? Does the first clause limit gun use to a militia? Or is it implying that the real focus is the last part, to allow people to bear arms? When the Second Amendment was written, the Founding Fathers were deeply suspicious of large standing armies. They had just defeated one in the War of Independence, so they saw militias as people's main form of protection.
Those who were skeptical of the Constitution, who we call the Anti-Federalists, they thought the federal government would be too strong and too overwhelming. And so what happens is the Bill of Rights is adopted kind of as an afterthought and kind of as a palliative for the Anti-Federalists. Well, okay, you're suspicious that the government will grow too strong and too powerful. We'll put in this Bill of Rights.
The Second Amendment, by providing protections for a well-regulated militia, was intended to reduce the need for full-time soldiers. The United States didn't even have a Department of War until 1789. These days, most Americans look to the military as a guarantor of their security, rather than a threat to it. A fight today between a militia and the American military wouldn't be a very fair fight. Instead, we rely on other defenses to guard against a military state, on the courts and on checks and balances. Seen with the militia interpretation, the Second Amendment seems pretty out of date. So how are we to understand the second part of the Second Amendment, the right of the people to keep and bear arms? As long as Americans have had guns, there have been rules to regulate them. Early American laws regulated the sale and storage of guns and ammunition, and put restrictions on gun ownership by free blacks, slaves, and Native Americans. There were even gun regulations in the Wild West. The gunfight at the OK Corral in 1881 was fought in part because cowboys were carrying weapons in violation of a city ordinance. In 1939, in a response to gangland crime, including the St. Valentine's Day Massacre, the Supreme Court found in U.S. v. Miller that certain types of guns could be regulated and taxed under the National Firearms Act. Over the years since U.S. v. Miller, the Supreme Court didn't really challenge restrictions that states made on guns. Until 2008. A case came to the Supreme Court challenging a Washington, D.C. law that required guns to have a trigger lock, even in the home. Written by Justice Antonin Scalia, the Supreme Court opinion in District of Columbia v. Heller concluded that the law was overly restrictive. The court found that people should be able to own guns for traditionally lawful purposes, such as self-defense within the home, flipping the standing interpretation of the Second Amendment, from being a collective right regarding militias to an individual right to own guns. Although in its decision, the court said that right was not unlimited.
This was a conservative court, a court that was in the process of telling the nation's capital that it couldn't do certain things, and it went out of its way to say, listen, we're saying that this is a right that can be regulated using evidence and public health and reason. Do you want to prevent guns from getting into special sensitive places like schools? Yes, you can do that. Do you want to regulate dangerous and unusual weapons? Yes, you can do that.
And that's where we stand today. The Supreme Court has found that the Second Amendment doesn't stand in the way of new gun control laws being created or old ones being thrown out when they no longer serve their purpose. The only reason new federal gun control laws aren't being created or outlawed is simply political will.